Hi, everybody. Thank you, Katie, for the introduction. It's great to be a part of this event. And I'd like to thank Catherine and Tom for organizing this teach-a-thon. So today I'm going to say a few words about rape culture and law and focus specifically on the role of law in both perpetuating and legitimating myths and stereotypes about women and rape. So by now, everyone should have a pretty good sense of what rape culture is, and if not, I'm sure this will be the case by the end of the day. But for this talk, it'll suffice to say that I use the term rape myths to refer to the commonplace and pervasive assumptions that circulate in our society about women and rape that in varying ways excuse, justify, and trivialize sexual violence. And to understand the devastating effects of rape myths, as well as the social and cultural forces that give rise to them, there is perhaps no better resource to turn to than the men who have committed rape. So I'm going to begin this talk with spending a few minutes discussing one of the first sociological studies that offered empirical support for the argument that there are cultural and social supports for rape. In 1994, a sociologist by the name of Diana Scully published a landmark study that involved conducting in-depth qualitative interviews with 114 convicted rapists. And at the time, she was really questioning some prevailing explanations within the disciplines of law and criminology that understood rape to be a disease, that medicalized rape, and assumed that rapists were men suffering from psychiatric disorders and that they were sick and generally had mental health issues. And these ideas resulted in the proliferation throughout the 1960s of sexual psychopath laws in various states in the US. So through her interviews, Scully wanted to challenge these prevailing ideas, and she found solid empirical evidence to support the conclusion that rape was not an act committed by a small group of pathological men who lacked control of their sexual impulses. And she derived these conclusions through comparing and contrasting the interviews she conducted with her sample of 114 convicted rapists with interviews she conducted with a control group of 75 convicted felons who did not commit rape or acts of sexual violence. And although these two groups had a number of similarities in terms of family background, childhood, involvement in crime, there was very little difference between these two groups when it came to mental health and the presence of psychiatric disorders. The convicted rapists were not any more likely to suffer from psychiatric disorders than this group of felons. However, where they did differ significantly was the degree to which the convicted rapists believed in and accepted myths and stereotypes about women and rape. And this might seem like an obvious finding. However, it is an important one to reiterate, given that these are myths and stereotypes that we are all exposed to and are often left unquestioned in our society. So let's briefly take a look at some of her findings and some of the justifications that men who rape provided for their crimes. So the first one I'm going to go through is the idea that nice girls don't get raped. We've all heard this one before. If a woman has a sexual history, if she's walking alone at night, if she's drinking, and of course if she's wearing revealing clothing, these will all factor into determinations of whether she is a good or a bad woman, and by extension, a legitimate target for rape. Scully refers to these as pedestal values. They're essentially double standards that require women to be more virtuous than men. And in her study, she found that 78% of the men who denied their crimes used their victims' alleged sexual reputations to justify their actions. Another myth that circulated in these interviews was the idea that women mean yes when they say no. Again, we've all heard this one before. Perhaps it's effective to read a direct quote from one of the convicted rapists in her study to really illustrate the effects of this. So, quote, this is what one of the research participants in her study said. Quote, "A man's body is like a Coke bottle. Shake it up, put your thumb over the opening, and feel the tension. When you take a woman out, woo her, and then she says, 'No, I'm a nice girl,' you have to use force. All men do this. She said no, but it was a societal no. She wanted to be coaxed. All women say no when they mean yes, but it's a societal no, so they don't have to feel responsible later. And also intertwined with this myth was the idea that women don't physically resist enough, or they need to physically resist enough for their no to be heard. And a third myth that frequently circulated in her study was this idea that rape was really no big deal. The convicted rapists in her study would often say, oh, I shouldn't have used a weapon, or I shouldn't have hit her, but they did not think that rape was a problem. And finally, interlaced with all those other narratives or other myths was the idea that women lie about rape. So this study provides us with insight into the perspectives of sexually violent men, and most importantly, the broader social and cultural factors that serve as the foundations for their perspectives. But in drawing attention to these findings, I don't want to suggest in any way that the extreme acceptance of these myths is exclusive to criminalized and incarcerated men. As we know, and as you will hear about later on today, the unquestioned beliefs in these myths is just as prominent in the university as it is in the prison. And they also surface in the reasoning not only amongst those who are subject to law, but also amongst the very people who have been enlisted with the responsibilities of upholding our law. So I'm sure a lot of you have heard about the case involving Justice Robin Camp recently, where he basically indicated in his acquittal of the defendant that the complainant just should have put her knees together, right? He also, to support his decision, indicated that the complainant should have moved in a different way to avoid the assault. And we can really see the parallels here between his perspective and some of the quotes I've just read to you from the convicted rapists. This has also happened before. In the late 1990s, there was a case involving Stephen Iwanchuk, and in the first case, the judge in the matter found Iwanchuk not guilty on the basis of implied consent, which doesn't even exist in law. So he essentially made up a particular defense of implied consent, which the Supreme Court later overturned. And when the Supreme Court was reviewing this decision, they stumbled upon a number of myths and stereotypes in McClung's reasoning that he used to excuse Iwanchuk's actions. So, for example, when McClung described the accused's sexual assault, he trivialized his actions as, quote, clumsy passes and romantic intentions. He also asserted in his judgment that the defendant's, quote, advances to the complainant were far less criminal than hormonal. He then went on to suggest that in, quote, a less litigious age, going too far in the boyfriend's car was better dealt with on sight. A well-chosen expletive, a slap in the face, or if necessary, a well-directed knee, end quote. So notice again the similarities between the earlier quotes I shared with you and these from the judge. In addition to justifying his finding of not guilty, Judge McClung also found it relevant to comment on the complainant's attire. In his judgment, he asserted, it must be pointed out that the complainant did not present herself to Iwanchuk or enter his trailer in a bonnet and crinolines. In the interest of time, I won't be able to give you all the details about the case, but it will suffice to say that Iwanchuk was a stranger, and he and the complainant were not dating. Rather, he approached the complainant with the offer of a job, and the assault happened within the course of a job interview. The evidence also indicated that the complainant said no on several occasions. In addition, after the assault, Iwanchuk gave the complainant $100 and asked her to keep quiet. And this was all presented during the course of the trial. It is also worth noting that in 2006, Stephen Iwanchuk was declared a dangerous offender after he was found guilty of sexually molesting an 8-year-old girl. He had had a string of sexual assault offenses and rapes dating back from the late 1960s. So in both of these instances involving McClung and Camp, there were consequences for their actions, right? The Supreme Court overturned McClung's decision, and Robin Camp has faced repercussions for what he has said from the Judicial Council of Canada. And he is now being ordered to undergo sensitivity training. So both are facing these repercussions, which is reassuring. However, when we think about rape culture and law and how they influence each other, I actually find the more frightening cases to be the ones that are far more subtle and how they legitimate myths and stereotypes about women and rape, particularly the myth that women lie about rape. So to do this, I'm just going to spend the remainder of my time discussing the recent high-profile case involving Jian Ghomeshi, the former CBC radio host of Q, which resulted in his acquittal of multiple counts of sexual violence involving 3 different complainants. So again, this case is also far too complex to go into detail about the specific circumstances that led to his acquittal, but it will suffice to say that what really happened was that new evidence emerged during the course of cross-examination of the complainants in the midst of the trial. And this significantly impacted the ability of the judge to find Ghomeshi guilty beyond a reasonable doubt. And legally, the finding that the judge delivered was the correct one. However, at the same time, I have no doubt that the complainants were telling the truth. So how can this dissonance make sense? So there are 3 very specific points I'd like to end with, which will allow us to contest the legitimacy of the law in this instance, while also acknowledging that technically, the law could not side with the complainants in this case. The first is, we need to contest the idea that legal findings are objective truth, and that there can only be one truth in these cases. The law assumes that the truth is out there to be found and to be discovered. However, in reality, the law manufactures an idea of truth. It manufactures objective truth, and it constructs it. And it does so through the application of legal reasoning, rules of evidence, assessments of what is credible and reliable, and in the process, it produces a particular kind of truth. But again, this isn't objective truth and the only truth. This is a legal truth. The second point I'd like to make is that in order to be recognizable as truth by law, stories have to follow a particular format. They need to be consistent, they need to be linear, the facts can never change, and allegations must be told right away. And given this, the third point I want to make is that this could be particularly difficult for survivors who undergo the trauma of sexual violence. It could be particularly difficult for them to relay their stories in a way that can be recognizable as truth by law. In the aftermath of trauma, the immediate response of those who experience it is to forget the incident ever happened. In fact, forgetting, as trauma experts have shown, is often how we survive trauma. The result of this forgetting for rape survivors will often be changed or delayed and inconsistent stories. Stories that also become increasingly more detailed as they actually recover from the violence and start to remember and process what happened to them. Denial and self-blame will also be a part of this process. And particularly when the accused is an acquaintance or a love interest, as was the case in the Ghomeshi trial, conflicting feelings and a desire to deny and forget, to maintain some kind of sense of normalcy and even harmony are not at all uncommon. So all of these factors will complicate the ability of complainants to speak their truth in the way that the law needs to hear it, in order for it to be legally defined as truth. Linear, consistent, holistic, and relayed right away. And one consequence of this is the assumption that survivors of rape are often, to use the exact words of Justice Horkins in the Ghomeshi case, being deceptive, quote, deceptive or manipulative when inconsistencies, new evidence, and delayed reports surface. So to conclude, I think these more subtle processes that draw our attention to the infrastructure of legal reasoning, rather than the blatant surfacing of rape myths in judicial decision-making, I think it's the former that we really need to be mindful of when trying to understand the various ways in which the law perpetuates rape culture and rape myths. Because the reality is that we are doing a pretty good job of identifying sexist judges and questioning their behavior. But tracking and addressing these less obvious ways and more subtle processes is far more challenging. Thank you very much.